This is Trial Transcripts Exposed by Crime in Court with Heather. Raw courtroom reads with my commentary. Let's dive in. Hi, everyone. Welcome back to Crime in Court with Heather. This is Trial Transcripts Exposed, and we are reading through the Menendez brothers' retrial. Their 1996 trial. We have made it to 1996. It started in 95. So we are actually on January 11th of 1995, and we've got some arguments. So Erik Menendez has just completed, if you recall, he just completed his testimony. So they just finished him on the stand, and now they've taken breaks continuously throughout the trial to have little side arguments and things. And part of that they did during Eric's testimony was about Dr. Wilson. So we've been having a lot of argument about Dr. Wilson. We're going to have a lot more today because he's about to take the stand. We will get to the beginning of his direct, but it's going to be a battle before we get to it. So let's get started. But before I do want to thank our um, our founding Justice Insider. So thank you, Toyota Girl 67, SLB 29488. May the force be with you 4313. Jessica Wienand 6079. Mrs. Apples 2007. Butler 89833. Brooke JF, Jen P 773, Boom Chicka Wow Wow 1, and Kendall B 5757. Thank you so much for your founding Justice Insider memberships. You can also become a founding Justice Insider member and have your name read off on screen. If you join my membership level, the Justice Insider tier, from now until June 30th, that perk is available. You will always have the designation of Founding Justice Insider going forward. All right, so let us get to our main topic today, and that is the trial, the continuation of the Menendez brothers trial. So, like I said, we are beginning the morning of Thursday, January 11th, 1996, and we do not have the jury present. These are going to be arguments um, outside their earshot. So, here is arguments over Dr. Wilson. The court says, all right, the defendants are in court, the lawyers are here. Any matters to discuss before the testimony of the next witness? Ms. Abramson says, we don't. Mr. Khan says, yes, Your Honor, we met with Dr. Wilson the day before yesterday, and we had an adequate opportunity to speak with him at that time. However, I think that the opportunity to speak with him just highlights some of the remaining issues that are before the court, and that is focused upon the scope of his testimony. We filed a motion with this court previously in which we objected to 10 specific areas which should be limited. And I'm not suggesting, and I don't think that the court could rule in advance upon all of these matters. I'm sure the court needs to listen to the testimony to a certain extent to make rulings concerning those matters as they're presented before the court. However, at this time, I think that opportunity that we had to speak with Mr. Wilson makes us aware of key areas for which we would like to renew our objection to the testimony and to advise the court of where we believe the defense is going to go with the witness and which is to matters which are clearly inadmissible. If the court wished to have an inventory of matters that have been ruled inadmissible by the court, all the court would need to do would be to ask Mr. Wilson what he relied upon in forming his opinions. Strong words there. Because it's very clear what they intend to do is have Mr. Wilson state the basis for his opinion, and that is all of the matters ruled inadmissible by this court. In specific testimony relating to psychological maltreatment occurring all throughout the life of the defendant. In fact, The witness indicated to me that he had charted out instances of psychological maltreatment throughout the entire course of the life of the defendant, and that he has related such instances of psychological maltreatment to post traumatic stress disorder. It is his opinion that the defendant was suffering from post traumatic stress disorder and battered person syndrome throughout his entire life and continuing until this day. And so it's clear that they intend to present through this witness the entire psychological history of the defendant, including all incidents of emotional and psychological abuse, as a basis for his opinion concerning the defendant's state of mind at the time of the commission of the crime. Well, all that stuff that happened in his past relates to how he is thinking in the present moment of the crime. All the things that happened to him in the past by his father, it weighs on him emotionally, psychologically. It's all you can't just escape it. You can't just ignore that it happened, but that's what the prosecution here wants us to do. So, we would once again renew our objection to evidence concerning psychological maltreatment because I think that they're doing now, what they're doing now, that the court has ruled that such testimony is inadmissible. They have just taken the testimony of Dr. Hart and are now seeking to present it through Dr. Wilson to present all these matters which have been ruled inadmissible. So we would object, first of all, to any evidence of psychological maltreatment, whether or not such evidence of psychological maltreatment relates to battered person syndrome or post traumatic stress disorder. The key issue before the court and the jury is whether the defendants were in fear or of imminent danger at the time of the commission of the crime, and the court has ruled these matters inadmissible because they do not go to that particular fear. How do they not, Judge? How do they not go to that particular fear when everything you've ever known about your father is that he is a violent man who has threatened to kill you in the past and kill other people in the past? You can't just say that his memories of his father, all the bad memories of his father are wiped away at that moment because he's in fear at that moment. You still have to consider the things that happened in his past to get an understanding of his state of mind during the commission of the crime. Is that not what you want? And the court has ruled that these matters inadmissible because they do not go to that particular fear. So we would object to the defendants presenting an intermediary fact, that is, post traumatic stress disorder and battered person syndrome, and now alleging, well, even if psychological maltreatment doesn't prove fear, psychological maltreatment proves the intermediary facts which we have not constructed. And therefore, they backdoor it and get in psychological maltreatment for proof of an intermediary fact that they have constructed. So, that is one area of objection that we would like to bring to the attention of the court. Second area of objection that we would like to bring to the attention of the court is evidence of psychological maltreatment or state of mind at the time other than the commission of the crime. It is only the day before yesterday that we learned that we now have an opinion that the defendant suffered from a mental disorder, post traumatic stress disorder, and his condition, which they refer to as battered person syndrome, throughout his entire life. So, what we would ask is that as the court had and the people, when we were seeking to examine Erik Menendez in regard to his relationship with Dr. Oziel, the court had the people focus on December 11th, recognizing that that was the key area of examination that we wanted to get into. And the court ruled that, well, whether or not the people can get into the nature of the relationship a year before will depend upon a showing by the people that it is necessary to get into that relationship. And as it turned out, by focusing first on December 11th and asking additional questions relating to October 31st and November 2nd, it really wasn't necessary to get much into the relationship prior to that. I think that we were able to elicit all the relevant information that we wanted to by focusing on those dates. What does this have to do with anything? So, once again, we would ask that the same approach be taken in regard to the examination of Dr. Wilson. That is, the key focus of this court and the jury is the defendant's state of mind and at the time of the commission, the state of mind at the time of the commission of the crime. And we would object to any other testimony concerning other periods of his life other than that particular point in time. The court says, all right, did the defense wish to respond? Well, a few things, says Ms. Abramson. Yes, I'm glad she's arguing. She says, first of all, she's so fun to read because I can like feel the passion in her voice when I read it. She says, first of all, I object to the people referring to Dr. Wilson as Mr., which is a ploy they try to use before with defense experts. Someone who qualifies as a doctor, he should be referred to appropriately as a doctor. And we'll start with that. The second is that Mr. Khan has mischaracterized to the court what Dr. Wilson is going to be testifying to. There's tape recordings of the 1 hour interview that was conducted by Mr. Khan and Dr. Wilson, and nowhere does Dr. Wilson say that he intends to testify to all the instances of psychological abuse, nor does he say that that he is relying upon the testimony of Dr. Hart, or in fact even had even that he read the testimony of Dr. Hart. He never even indicated that. And there's been, and I can tell the court, we have no intention of bringing out all instances of psychological abuse in this family, or we would be here for 10 years. I repeat, we have no intention of bringing out all the instances of psychological abuse in the family, or we would be here for 10 years. I mean, that's probably true. You could do, if they had let it in, this trial probably would have gone a lot longer. So there are two different things, as I understand it, that our expert witness can testify to. Two parallel tracks, if you will. One of them has to do with the diagnosis of my client at the time of the homicides and during the days immediately preceding that, to determine if a mental condition that he suffered from contributed to the behavior that resulted in the shootings or the behavior of the shootings. And that is what we intend to do under PTSD analysis. Now, in addition to that, the prosecution spent at least a day cross-examining our client with the sole purpose of being able to ask him repeated argumentative questions about why he didn't leave his family. And we are not talking about why he didn't leave on August 20th, why he didn't leave the whole week, why he didn't leave earlier in his life. And so, just as one example of the common misconceptions about how abused people deal with their situations, the prosecutor harped repeatedly on his failure to leave, clearly arguing through that questioning and trying to establish that if he had been abused, he would have left. And his failure to leave shows that things were just peachy. And we know now, I think most of society, common public knowledge, that that's obviously not the case. Um, People who are abused often don't leave their abusers. They're afraid to leave their abusers, and it's actually the most dangerous time in the relationship. And that's when the psycho, narcissistic, crazy ex wants to kill you or say, if I can't have you, no one else will, and take you both out. Or, that's often what happens in those situations. So it's not unheard of that the Menendez parents may have had a plan. And I stick to that. We learned in last episode that Jose Menendez did in fact, have ties to the mafia, or at least he talked about it all the time in front of his family. And back at Jersey, talked about having connections in Jersey. So there's that. And if he had ties to the mafia, which also had ties to the CIA, oops, we're not supposed to know that. It could all be one big giant thing that is being hidden from us about something. Just saying, there might be some more information about the Menendez parents that is being hidden from us. There might be some more damning information about them, rather. And the state is fighting so hard to keep these brothers in prison because they don't want them to find out. They're trying to correct or overcorrect for their error of, hiding, or their misdeeds of covering up some things that might be going on. I don't know. I just have a feeling that there's more to this than we know. And I'm not like a total conspiracy theorist or whatever, but These things are real. They happen. The CIA actually and the mafia were in cahoots, and lots of things were and probably still are happening at the behest of the CIA through the mafia and organized crime uh, sectors all over the world. Just saying. So, anyways, so it's very possible that Jose Menendez could have potentially found a way to get rid of Eric and Lyle if they were going to be a problem for him. And he seems like the type of person that would do that. And we know that based on Eric's testimony and Lyle's testimony and other family members' testimony. And yet we're still, the state of California is still trying to protect him. It just doesn't make sense why they're protecting him so hard, you know? Anyways, so now they conceded earlier on, and whether they conceded or not, the Eris case makes it clear that in a case such as this, we should be entitled to dispel common misperceptions about these types of battering relationships. And part of the explanation of why people don't leave battering relationships has to do with the nature of the interaction between the batterer and the batteree. And in this case, there are two batterers and one battery. And I believe we should be permitted to describe what the factors were in the interaction between the batterers and the battery that developed the state of helplessness and the other kind of self image deficits that people in battering relationships develop that make it difficult or impossible for them to make well reasoned, conscious decisions to extricate themselves from these relationships. God, she has a way with words. Like, God, I wish I could talk like her just normally. She's amazing at the way she argues and so fiercely and so eloquently for her clients. And with some snark, too. I love it. And that's where the battered person syndrome analysis enters. However, and we have to explain those things to dispel the very kind of inferences that Mr. Khan was trying to raise in his cross-examination. She's exactly right. He's trying to infer that you could have just got walked away. We know that that is not easy to do, nor is it always possible, and it's very dangerous. So, no, he couldn't have just walked away from the situation. But that's what Mr. Khan inferred. So they need to be able to get ahead of that, or not get ahead of it because it's already out. They need to be able to rebut that in their case in chief. On the side of the post traumatic stress disorder, there are instances of what perhaps Mr. Khan may think of as psychological maltreatment that have a direct connection to creating fear states. And we believe the nature of that treatment or those events are relevant on this issue of fear. There are two tracks that we intend to follow to stay within the court's previous pronouncements and the law as we understand it in the state at this time. And we also are considering the law having to do with not just imperfect self defense, but also provocation theory, provocation heat of passion theory. Ooh, I don't know much about those. That'll be interesting to hear some arguments about that and the imperfect self defense, which I'm sure we will get into eventually. And those two tracks are fear and the reaction to perceived threats and helplessness and inability to extricate from the situation. And those are the two tracks that we intend to stay on in the examination. So, fear and the reaction to perceived threats, that's one, and then helplessness and not being able to leave, not being able to help yourself in many instances because your parents have made it so that you are dependent on them so much that you can't function on your own. And you wouldn't even know how because they make every decision for you. Sorry, I embellished a little there. So we have all Dr. Wilson said, and the people have a tape of it, Your Honor. We all have a tape of it. All Dr. Wilson said, we asked him what what had what had he done to prepare? What was he relying on? And he indicated that he and Dr. Hart have consulted and have, between the two of them, created certain charts having to deal with certain categories of psychological maltreatment. That's all he said about it. Now, the people are jumping to wild conclusions. They had every opportunity during the hour to ask Dr. Wilson about what how much of that information or what type of that information was he relying on? Was he planning on testifying about? And they didn't ask him. All they asked him by way of, they asked him, the whole discussion was about what did he, basically, what had he done to prepare? What was he relying on? How much time did he spend with the client? Then he gave a whole list of the things he had was relying on, whose testimony, what kind of testimony had he reviewed, and they asked him for specific names of some witnesses whose testimony he had reviewed, what records had he reviewed, and he told them about the different records. There's a lot of discussion just about the different kinds of records that he relied on. Talked about the charts that he and Dr. Hart had worked out for his own use. These are not charts I'm seeking to present in court. And then they talked about the psychological testing in he was asked for the great detail about describing the tests. I just paused for a second and because I heard a noise and now I don't know where I was. So if I read this already, sorry. And then they talked about the psychological testing he was asked for the great detail about describing the tests. He was asked about his notes, which the people were given at the conclusion of the interview. He indicated some partial reliance on one opinion of Ann Burgess, and he was asked about his conclusion concerning sexual molestation. He talked about photographs he had seen, autopsy reports, talked a little bit about biochemical changes that can be caused by trauma. I'm just reading my notes from that interview, Your Honor, so the court can understand the people are just Im- imagining problems that I don't think we're going to have. Talked some more about some physical tests that are now done, talked about what were the trauma inducing events, and his answer was primarily repeated sexual molestation. Sorry, my dog's squeaking a toy. And his answer was primarily repeated sexual molestation. Asked if he had an opinion as to what caused this homicide, not if we were going to ask that opinion, but just if he had one, and he gave them his opinion. Asked about his opinion concerning the client's credibility, and he told them. And that was it. That was what the interview was all about. Court says, okay, anything further from the prosecution? Yes, says Mr. Khan. I don't know why counsel's relating to the court what went on in the interview. The issue before the court is not what went on in the interview. The issue before the court is whether we're going to take testimony concerning psychological abuse. And I think counsel just confirmed what I'm saying to the court, and that is that she intends to present evidence of psychological abuse, which is not relevant to the fear of the defendants, the alleged fear of the defendants at the time of the commission of the crime. She erroneously relies upon People versus Eris for the proposition that evidence of psychological abuse is admissible. It was not admissible in Eris. People versus Eris related to physical battering, which resulted in this condition known as learned helplessness. Here, counsel seeks to use evidence of psychological abuse to establish such learned helplessness because this is a witness who, in the testimony that he gave in the hearing before this court, indicated that he regards battering as including just purely psychological abuse. So, as long as he's creating his own definition of what is a battered person, and as he testifies to the condition known as the battered person syndrome, which is not recognized, he can create his own conditions as to which will constitute that condition known as the battered person syndrome. So we'll be able to say that psychological abuse is evidence of that condition and then get into purely psychological abuse. So we would object to testimony once again of that nature. The other area that we'll object to, we made an effort to contact our witness in Washington, D.C., who would testify to the so-called neurobiology of fear, and Dr. Restak back in Washington, D.C., advised that he will be available to come in next week. He can't be here before Thursday because he has to testify in another matter on Tuesday of next week. So we would ask that this witness not be permitted to testify in regard to that trauma results in permanent biological changes in the autonomic nervous system, which creates a lower threshold in which a person responds to fear. This is such BS that they won't let this in. it's fact. I mean, we know this is true now. I don't know how this is being disputed by the state, but it is. We feel that there is no science which supports that conclusion and that Dr. Restak will be able to demonstrate that in a hearing before this court. So you're going to have some psychologist tell you that you don't get changes in the autonomic nervous system? Because my autonomic nervous system is effed because, well, I think because of abuse that I endured by my ex, or at least it really, if I had POTS my whole life, then it really like exacerbated it after that. Anyways, so I can attest to your autonomic system being not the same after being abused for some time. So we feel that there is no science which supports that conclusion and that Dr. Restak will be able to demonstrate that in a hearing before this court. So we ask that the court exclude such testimony. Ms. Abramson says, well, Your Honor, the problem with that is this, and I'll try to frame it for the court as there are two different things that I think are going. Well, let me back all the way up. It has been known for 100 years that extreme stress, what's known as traumatic stress, causes changes in people's behavior, in their emotions, in their moods, in their reactions, all of that. And therefore, it has been accepted as a valid hypothesis, just like all the other hypotheses about psychology have been accepted that there are biological changes in response to stress. And that's been accepted for about 100 years. Recently, in I don't know, the last 8 years or so, there has been specific measures that have been developed by way of various kinds of testing to actually quantify and measure how the nervous system is working to prove physically and medically that what has been understood all along based on clinical evidence is in fact provable in laboratories by measuring certain things in persons with known histories of traumatic stress, usually people with PTSD. Now, I am willing, as I've indicated, to not get into these new measures and physical proofs and specifics about which parts of the central nervous system, which part of the brain structure they now believe those who are knowledgeable in this field are permanently changed by traumatic stress until we can have the hearing where the people will have their opportunity to prove that all the research is not there. But with respect to the other components, the entire analysis of PTSD, the whole history of the research of PTSD is based on the fact that people exposed to traumatic stress then demonstrate this whole series of cognitive and emotional and affective and behavioral changes. That's how you diagnose it from the DSM 4 by noting those changes. Now, those are changes that obviously, and they're not a matter of conscious choice. Those are the way people with PTSD react, either keep re-experiencing the traumatic event or react to new stressors in these extreme ways. That's what typifies PTSD. That's how you define PTSD. That's how you diagnose it, and it's obvious, since we're dealing with a living organism, that there is something in that living organism that is causing these sensations, these emotions, these reactions. So the fact that and the same is true, that there's also been extensive animal testing to show that animals, and humans alike, show these same kinds of changes in response to traumatic stress. So the theory that there are newer biological changes is totally unchallenged. It's the proofs that are new. Moreover, the concept, for example, at one time the people were arguing about the concept of fight or flight. That's been extremely well studied. The only thing that now is they can actually measure the levels of all these complex and interrelated stress hormones. I'm more than happy to stay away from the measurement, the physical provability of this hypothesis, but without the hypothesis that there are neurobiological changes in result to stress, you don't have post-traumatic stress disorder syndrome, and I am certainly not going to concede that there is any dispute, and there isn't, that post traumatic stress disorder is something that involves the biology and neurology of the victims, because that's the whole basis of the diagnosis. That's the whole basis of the understanding of what it is and how it happens. And I can't present any evidence on post traumatic stress disorder without explaining what it is, explaining it as what it is. So, my point is, I'll stay away from the provability aspect of physical testing, which is the newer area. But to say, I mean, post traumatic stress disorder just happens to be one of those things that develops in people as a result of something happening to them. And from Janet and Freud, there has been no question that this is neurobiologically based events that are manifested in clinically measurable ways. And that's what it is. And we already had our hearing on both whether there is such a thing as battered person syndrome, and the people lost that and continue to indicate there is not. I don't know of any language in Eris that said any of the physiological, or I'm sorry, that the psychological components of that battering relationship were not admissible. The people constantly choose to misrepresent what psychological maltreatment is and how it fits into this picture. And to make assumptions about it, we've got plenty of abuse here of an individually traumatic nature, the psyche, anything that does not fit into a clear terrorizing category that we're presenting because it fits into an isolating category, which is the helplessness part of the explanation concerning the learned helplessness here. And there was nothing in Eris that said learned helplessness is something that develops only from physical battering. The people haven't one piece of research to support that conclusion. So all we're doing is staying well within the research on battered persons and PTSD, and we're only seeking to explain our client's conduct, which has been called into question in every particular, based on these components surrounding the sexual molestation that contributed to fear and helplessness. That's all we're doing. We don't intend to talk about dirty houses and dirty laundry and ferret poop or snails. That's a different issue. We're not going to talk about any of the actual findings of biological change or change in the brain until after we've had the hearing. But we're going to talk about the things that, in the opinion of this expert and every other expert that has examined Erik Menendez, contributed to his inability to extricate himself in the face of the danger of from his family. And if the people want to point to some language in Eris or any other case and say you can only describe the beatings and not describe the control, the domination, the jealous rages, the indoctrination, the brainwashing, the threats, all of that that goes on in battering relationships, let them point it out. But you cannot do these inhumane and unnatural and psychologically ignorant things, which is let's cut this out because the people don't like the evidence when they have not come forward with one piece of expert declaration or statement or literature or research that shows that there is no psychological maltreatment component to battered person syndrome or PTSD or learned helplessness or hypervigilance or any of the other concepts that the court in Eris said were relevant in a case such as this. Mr. Khan says, concerning this whole issue of the neurobiology of fear, I think that the clear, bright line is the difference between psychology and biology. And what counsel is suggesting to the court is we can't possibly present evidence of psychology unless we also present evidence of biology. Why is he separating the two? And I think that that is just preposterous on its face. She is suggesting that she cannot possibly present evidence of the battered person syndrome or post traumatic stress disorder without talking about the physical changes in the body that are related to such conditions. And again, I think that that is preposterous. I think your whole argument, sir, is preposterous. There is no reason that she should talk about the physical changes of the body related to those particular conditions. I'm sure that if you were to take sadness or happiness or any other human emotion, you may be able to find some biological enzymatic change in the body associated with such conditions. It doesn't mean just because the defendant says, I was happy or sad at a particular point in time, that they get to call an expert to talk about the biological basis for such changes in the human body. That just goes to show how ignorant this guy is when it comes to psychological abuse, any abuse, the effects, the psychological effects of abuse. He has no clue, and he shouldn't even be allowed to prosecute this case because of his lack of knowledge. I think that what she is attempting to do by saying, well, we'll present this type of biology, but we won't present that type of biology, is to draw an arbitrary line. She's drawing the line that, or actually, you drew the line, sir, and she's just trying to accommodate you, which she can cross as she sees fit because we still don't know precisely what she's going to get into, and she'll be able to get into what she wants before we even have our hearing. So I would ask that the court order at this time that we adhere to that clear, bright line, which is psychology versus biology. Let the witness testify to psychology today. If they want to get into biology, then I ask that we have a hearing first. The court says, all right, let me inquire of a few matters here. On the theory of provocation, you seem to relate that to learned helplessness in some way. Is that what you're doing? Miss Abramson says, no, I don't think that that's what I was talking about per se. I think I'm talking about the theory of provocation having to do with certain events that are not what I'm talking about, is events other than actual sexual molestation that were abusive and would come in under the notion of repeated provocations over time. It has to do with the cases, Your Honor, that talk about the fact that in weighing provocation, you can look over a whole series of acts in history. So I'm talking about kinds of behaviors that are meant to engender fear of Mr. and Mrs. Menendez in Erik, kinds of behaviors that constituted threats, even if they weren't expressed directly as threats. The court says, well, this is then fear producing behavior, is what you're talking about. Ms. Abramson says, but not individually, directly fear of death. It's a series of, the court says, well, the end result was fear of death. Ms. Abramson says, yes, yes. The court says, well, again, it goes back to our earlier discussion that we had without resolution as to whether or not there really is heat of passion as theory here, or really the imperfect self-defense. Ms. Abramson says, I think there's heat of passion also, Your Honor, and rather than, the fear obviously goes to imperfect self-defense also, but the court says, well, my concern is that you use this argument of heat of passion and provocation and then relate that back to any or the conducted interaction between parent and child that is selected as an example of provocation, when in reality, what your position is that those acts, that behavior was fear producing and produced the type of fear that the defendant described in his testimony that provoked him and caused him to act as he did. And really, all we're talking about then is mental state of fear, of depending upon how one evaluates the factual scenario as to whether or not that is fear of imminent death or great bodily harm, of some fear of some future danger. But still, it's not the provocation and the heat of passion that one thinks of when one uses the heat of passion definition of manslaughter. Well, except, Your Honor, says Miss Abramson, the court cuts her off and says, so my concern is that you're going to use, your effort is to introduce what are described as provoking acts, characterized as such and titled such, and then connect it in some way to provocation, heat of passion, which really doesn't match the facts here. Miss Abramson says, no. I tend to disagree on this basis. That there's nothing that says that the passion can't be fear. The court says, no, that's the whole idea. But when your heat of passion is fear, then you fall within the context of a homicide, imperfect self-defense. No, not necessarily, says Ms. Abramson. The court says, in this context of unreasonable belief, if it was a reasonable belief, then you would have self-defense. Ms. Abramson says, I do not believe heat of passion is subsumed in imperfect self-defense. The court says, I'm not saying that they're always subsumed. I'm just talking about the facts of this case, that clearly they're not. Heat of passion and imperfect self-defense are separate entities entirely. They developed separately over time. the issue is, in this case, based upon what your defense is and what the defendant's testimony is, that he wasn't acting out of anger or hatred, only fear. And if that's the only emotion, then it's difficult to conceive that you have true heat of passion provocation, because that's a reasonable man standard, and it doesn't track with the imperfect self defense. Ms. Abramson says it's a reasonable man standard with respect to the nature of the provocation. It is not a reasonable man standard with respect to the behavior after provoked. And our contention, therefore, is that in measuring, if a jury were to measure the adequacy of the provocation, they have to take into consideration the history of provocation as well. At that point, if the jury believed that the provocation was such that with that history, a person in like circumstances would react emotionally. At that point, he doesn't have to be reacting reasonably. And the court says then it's not heat of passion manslaughter. Miss Abramson says, "Of course it is, Your Honor. If you require someone to react reasonably, then what is it that the passion is supposed to do? The instruction talks about passion clouding reason, so the reaction does not have to be reasonable. The provocation, the perception. The court says the individual has to be behaving as a reasonable man." Ms. Abramson says, "In like circumstances." The court says, "as a reasonable man, not a life history of abuse, but as a reasonable person." Ms. Amerson says, "in like circumstances." And the cases have indicated that within the construct of like circumstances, you can evaluate the history of provocation and interaction between the actor and the provoker. And there's a recent case, I think, that makes this very clear, which is People versus Sanchez. Mr. Gessler and I were talking about it. I have not read it, so I'm not going to explain it to the court. The court says, "I'll be glad to look at it." Mr. Gessler says, "December 20th, 1995, Daily Journal, Your Honor." The court says, "If you can provide a copy for me, I'd like to see it." Mr. Gessler says, "I believe I might have one here." The court says, "Okay, I'll be glad to take a look at it." Abramson says, Do not remain in this legal debate, because I really think the issue here," the court says, "let me stop you, because another question I have has to do with proposed testimony of the witness, Dr. Wilson. During the testimony of Erik Menendez, quite a bit of evidence was introduced of interaction between himself and his parents, which clearly looked at objectively was not just that one would characterize as fear provoking, although the nature of the questioning was trying to connect it with fear at the time of the killings. Was this something that affected you and things of that nature? But again, it brought out evidence of of interaction between the defendant, the witness, Erik Menendez, and his parents from early childhood on, and we had testimony about dreams and terrorizing and things of that nature. And also, the court ruled that in pretrial hearings that certain witnesses would be permitted to testify about certain acts, and those witnesses were identified, and also certain behavior, if it became relevant, displayed by the witness, the defendant, Erik Menendez, and symptomology that would be consistent with the diagnosis of Dr. Wilson if it became relevant, and that issue during his testimony. My question is, other than the specific acts described by the defendant and those that have been ruled admissible by the court, did the defense intend to go into and have Dr. Wilson testify about other behavior between the defendant and his parents? Yes, says Ms. Abramson. The court says, and Ms. Amerson says, under the theory that we are entitled to dispel common misperceptions about the nature of abuse relationships and the reaction of abused people to the abuse, and because the people kept harping on why our client didn't join the army or go to other people, we should, as part of the whole construct of learned helplessness, we intend to prove certain patterns that made our client extremely isolated without an ordinary support system with which to deal with the abusive home environment. The issue of relevance in the abstract. The court just, I mean, here's the problem as I perceive it for us in trying to prove our case here, Your Honor. The court has made the conclusion that certain behaviors that were testified to were not fear provoking. Now, with all due respect to the court's intelligence, for which I have a great deal of respect, the court is not a psychological expert. There are behaviors that may not, on the surface, appear directly fear provoking. that nonetheless contribute to the development of one of these anxiety stress syndromes, where the whole point of the PTSD is that people suffering from it overreact to perceptions of fear. It is a fear causing ailment, and it is one characterized by people overreacting to cues of fear. So, although to you or I, Your Honor, a certain thing may not appear on the outside to be fear provoking, when it happens to you and your three, and similar behavior that pushes the same button happens at 6 and at 8 and at 10, and these patterns are repeated so that when you're confronted by the person who's been scaring you to death your whole life at 18, by the time you're 18, it is relevant to show why you would react the way you did at 18. The court has taken a legal position that I understand is an appropriate legal position in certain ways when it was held that certain events are, quote, too remote. They may be too remote in the standard logical sense with which we analyze evidence. She is arguing this beautifully. Watch him shut her down, anyways, though. So they may be too remote. I don't know that for a fact. He may let some of it in. We'll see, but we've seen how he's been ruling, so I don't have a lot of faith. They may be too remote in the standard logical sense with which we all analyze evidence, but this may be counterintuitive thinking. I mean, this may be intuitive thinking and logical thinking on the part of the court, but absolutely wrong from a psychological standpoint. What I believe is true, based on my understanding from my experts and what my expert is prepared to say to a very limited extent, because we're not going to be dwelling on these things, is that what happens to you at 2 can be the most significant fact in your life. What happens to you especially if we're talking about long-term family relationships that result in violence, what happens if the earliest years can in fact be the most significant facts to determine how to turn out and why you react to certain situations. And I don't think that making decisions about remoteness based on a time logical continuum is necessarily appropriate when we're talking about human psychology involving children. I would agree that if we were talking about adults and we were talking about a series of events between two adults, those 20 years ago may be less significant than those 2 weeks before the incident, but it is different when you're talking about children because things that happened early in their development or in their childhood affect the way they develop and impact how fearful they will be, how hopeless or helpless they will be, and how incapable they would be of making decisions to extricate themselves from different situations. The court says, all right, you said you wouldn't be dwelling on it. What did you mean by that? Is the witness going to describe the details of incidents? Some, or summarize them, or what? And how long and how much evidence? And then would that be followed by an offer of witnesses to corroborate that, or what is that's going to entail here? Ms. Abramson says, I believe, if I understand your ruling, Your Honor, if I understand it, what the court has held is that although the expert may rely upon information from a source witness, we only get to call that source witness for that information if the credibility of the information is challenged. That's how I understand it. So my understanding is, the court says I never said it in that way. I also said that Ms. Abramson says that's what I thought you meant. The court says the issue as to relevance, and there were other factors that would. Ms. Abramson says I'm assuming that. The court says not just because something is in dispute, it automatically becomes inadmissible. Ms. Abramson says, all I can say is that if my witness testifies to what is significant and important and appropriate in entering into his consideration of the issues before us, which is PTSD and fear and the helplessness, I can't imagine that the court would say that's not relevant by interposing its own expertise. Now, if we were to bring in things where the witness could not or did not connect it to these crucial issues about PTSD and hypervigilance and hopelessness and helplessness and that, then I would agree it's not relevant, then we should be stopped from asking the question. But if the witness can demonstrate to the court, can explain to the court and the jury why certain things are relevant and it makes sense, then they're relevant. And then the court says, There's another issue here that, again, things get sort of combined. The concept of learned helplessness and the defense response to the prosecution's cross examination. Getting my feet eaten by my dog. Hold on. Sorry about that. All right. The court says there's another issue here that, again, things get sort of combined. The concept of learned helplessness and the defense response to the prosecution's cross examination relating to why didn't the defendant leave the home at age 10, 12, 14, 16, whatever the age was. Ms. Abramson says all those ages, Your Honor. The court says whatever it was. That is a separate issue from the issue of imminent danger. There is a concept here that is getting combined, or concepts that are being combined that are separate. Imminent danger and why the person perceived at the time he killed that he couldn't escape is one issue. The other issue of why the person couldn't leave at some earlier time in his life doesn't relate to his mental state at the time he killed his victim. It relates only to a subsidiary issue of corroborating the defendant's testimony as to why he didn't leave at some earlier event. But it's a separate issue from his state of mind at the time that he killed, and it has to be analyzed separately. Otherwise, what you end up doing is introducing all the evidence on the theory of learned helplessness when the timing of this state of mind of learned helplessness, if that's how it's characterized, defines its relevance, his state of mind at the time he killed as to why he felt he couldn't leave versus at some earlier time it's different, and the focus of why the evidence would be received, its relevant, and the nature of the evidence that would be introduced has to be analyzed with that in mind as well. Why is he making it so complicated? Ms. Abramson says, I think that comes under the rubric of common misperceptions about abuse victims, and I have understood all along that we are to be permitted, as Eris indicates, to introduce evidence rebutting the common misperceptions, all of which Mr. Khan was relying upon in his cross-examination of our client. The court says, well, don't you have to look at the relevance of the misconceptions, assuming someone had a misconception about abuse victims? That really doesn't mean anything in regard to the case. Doesn't really have any relevance to the case. Are you kidding me? Why would you care about it? It has to focus on why it's significant to the issues for the jury to resolve. Ms. Emerson says, I do. The common misperceptions are that if you're abused, you leave. The court says, and people do. Ms. Abramson says, and my client didn't, and most don't. And so that's where the concept of learned helplessness comes into play. The court says, okay. But again, that area of relevance is the probative value of that and the relevance to the case is much less than the issue of the mental state at the time that he killed his parents. Ms. Abramson says, but his mental state during the whole week has been put into issue by the way he was questioned. The court says we're not talking about that week. We're talking about, although, again, certainly imminent danger didn't exist earlier in that week, but again, there are issues that have developed in the scenario that is presented such that is relevant during that week as to why he did or didn't leave. But then we get back to earlier times in his life and it becomes less relevant, even if there was a cross examination on it. Ms. Abramson says, I agree. The court says the concept of learned helplessness and what contributed to it in earlier times in his life is less relevant. Ms. Abramson says, I think the why he didn't, the court cuts her off and says, and it certainly has to do with the concept of imminent danger. Ms. Abramson says, well, Judge, the prosecution was permitted to ask why he didn't leave over the whole course of his life. Now, how is the credibility of my client less relevant? I mean, the fact is there are psychological explanations. The purpose of asking it was not to prove that he had helplessness. The purpose of asking it was to refute that he was abused based upon the common misperception that abused people are healthy enough to leave. That is all I'm talking about. The people were allowed to ask those questions. The defendant answered them. But we should be entitled, as Eris says, to put on evidence of why it is abused people don't talk, or why it is that abused people don't just walk out. And the failure to walk out, therefore, is not evidence that they're lying. That's the whole point of the prosecution's attack. Exactly. She has to be able to bring this out. If he denies this, this is garbage, absolute garbage. They were denied a defense. Now, I don't understand varying degrees of relevance It's an area upon which he was cross examined extensively. It's an area in which there's an enormous body of literature. It's an area in which courts have held it is relevant. And I don't understand how corroborating my client with the psychological reality of his position as a bettered person is of a lesser standard of relevance. It may not be the ultimate issue, but we don't spend our time in these courts only proving the ultimate issue. We prove the whole, as much as the surrounding issues, to help the judge figure out what's true, what's not true, and how to measure truth. We don't just put on ultimate fact, take it or leave it. And the whole point of putting on a psychological expert in a case such as this, I mean, theoretically, and certainly according to what the court has already said, mental states in issue, I've proven my case. The whole point in putting on a psychological expert is for a jury to understand in a scientifically realistic way that the behavior of my client is not aberrant and is believable or could be believed in psychological terms. Court says, right. That's why the court ruled that the evidence was admissible. But now we're talking about how it's proved and the basis of the what evidence is being brought before the jury that the analysis controlled by Section 350 and 352 of the Evidence Code as to relevance and potential for prejudice and undue consumption of time. Every one of these issues that you bring up, every example that you bring up, carries with it the potential of extensive litigation about what happened, what didn't happen at age 2, at age 4, age 6, at age 8, and that is part of an analysis that the court has to be concerned with as to whether this evidence would, in fact, be unduly time consuming and unduly confusing on the issues of the case. But this isn't stuff that hasn't been brought in already. I mean, there was plenty of stuff that was brought in the first trial, but they don't want all of it in. This is their ploy to get it to not come in. Ms. Abramson says, "Well, how about unduly illuminating, which is why the people don't want them in?" The court says, "I don't think that's the case. It wouldn't be illuminating, it would be confusing." He thinks having an expert talk about psychological effects of abuse would be confusing to the jury. No. Talking about something that happened 25 years ago or 20 years ago and trying to prove or disprove what happened then. This man sat through the first trial and heard all of that evidence about how trauma, abuse early on in life, and the long-term effects of long-term abuse, how it can affect one psychologically. He sat there and he listened through it all in the first trial. And now, for some reason, he doesn't think any of it is relevant or that it's just too confusing for the jury. I don't think so. I think he understood it. I think he just didn't believe it or something, or is really, really trying to get a conviction because he's fighting so hard, the defense, at everything. Where did I leave off? He says it would be confusing talking about something that happened 25 years ago or 20 years ago and trying to prove or disprove what happened then oftentimes tends to divert the jury's attention from the facts that are relevant. Ms. Abramson says, well, that may be true oftentimes, but as our experience in the previous trial in this case shows, there was no disputing of those events that were that were testified to. Right? In the previous trial, there was no disputing. There was no one from the state that got on the stand and said, Jose didn't abuse them. Not one person said that. Not one person disputed the abuse. In fact, more witnesses than not would confirm the type of person Jose and Kitty, the type of people that they were. The people never came up with any witness who could or did and still haven't disputed these specific incidents and the nature of the interaction between my client and his parents. It is not an area that's in dispute, and that's the whole point. There are numerous witnesses, I mean dozens and dozens and dozens, who confirm an authoritarian, tyrannical, and terrorizing household. And if the people want to concede it, we don't have to spend more than 2 minutes and a stipulation on that point. But the fact is, they've never been able to disprove it. There are no contrary witnesses or evidence. My understanding was that they don't challenge the credibility of the underlying information. It ends there, and we don't call the underlying witnesses. If they don't challenge the credibility, then I guess we can duke out who we should be able to call. But the fact of the matter, dogs incoming. The fact of the matter um, is that certain things are, I don't want to use the legal term relevant, certain things simply add up in the psychological experts. Every one of them, in this case, certain things matter scientifically or pseudoscientifically, if that's how you want to look at psychology, and for the court to make a decision about what's relevant before even hearing from the witness as to why certain things matter, I think is premature. The court says no. I'm not making any final rulings, but the concern is that all this then gets before the jury and then is ruled inadmissible and the prejudice is there. Ms. Abramson says, "What's the prejudice, Your Honor?" I don't know. I don't know what it is that's going to be said. That's the problem. Let me say this. I assume that you have foundational material that you are going to commence within the examination of the witness, his background, and things of that nature. Is that correct? Yes, his background, yes. Like with any expert witness. The court says, and then I assume maybe incorrectly that you have isolated in your examination of the witness the materials that we have just been discussing upon which he has relied. It's not spread out throughout the examination, but you've isolated. Ms. Abramson says, no, I was going to do it right up front, just the nature of the materials upon which he's relied. The court says, when you say nature, just that he spoke with people or reviewed materials, but not what the materials says? Miss Abramson says, well, I wasn't intending to do that in the beginning. I was going to indicate he reviewed materials from certain people of certain materials of certain types, and I was going to get all that in because that's how I intend to do it. What all do you see? What all do you see? Not the content, says the court. Ms. Abramson says, no, not content. Just put it all in what the materials were. This is very basic stuff, Your Honor. And then his contacts with the clients, the documents that he saw, any other experts that he consulted with, just as a foundation for where he's coming from, what his fund of knowledge is. Court says, okay. And as I said, did you have an isolated area of the examination that dealt solely with these early years of the defendant's life that he relies upon as to this isolation, terrorizing things of that nature? Your Honor, it's not in terms of focusing just on, it has to do with patterns. It has to do with seeing patterns of behavior and few egregious examples of the patterns of behavior that are significant for these issues of fear and terrorizing and isolation. Hold on. Sorry, I got interrupted. The dogs were being really rambunctious. I wanted to go take them out to play now. I think I'm done for the day. So I'll finish up this paragraph. Are you seeing my breath just from like playing with the dogs? So Your Honor, it's not in terms of focusing just on, it has to do with patterns. It has to do with seeing patterns of behavior and a few egregious samples or examples of the patterns of behavior that are significant for these issues of fear and terrorizing and isolation. The court says, well, he's going to describe them for reviewing materials that he has detected a certain pattern of behavior. He's going to describe them from reviewing the materials that the court's familiar with, the testimony of witnesses. No, says the court. I'm saying he's going to say there's a certain pattern of behavior, which is pattern X, and then you will then pick out an example or two to demonstrate that pattern of behavior. Is that what you're saying? That's how I sort of envisioned it. It wasn't all that rigid, but that's how I envisioned it. I can tell you what we're not going to do a little more than I can tell you what we're going to do. I have not asked this witness. I trust his expertise. I haven't gone through every single question and answer, and I don't do that with an expert. We have an enormous list of things that we have compiled over the years by Dr. Hart and others and Dr. Wilson. I do not intend to go through that list each and everything. We have them there as just a reference of the content. They do form patterns, isolating behaviors, terrorizing behaviors being the most prominent. So I do not intend to go through every rotten thing they ever did. First of all, it would trivialize the important things. And so from an analytical standpoint, you don't go through everything, but I think it's important to show certain patterns and indicate that and the other thing too, Your Honor, that I think is important for us to be able to do without beating it to death is to show that contrary to the presumption that Mr. Khan tried to raise with the jury to much of what my client testified about non-sexual abuse, there are witnesses. There were people who saw things just to establish that this case does not rise and fall solely on the believability of someone who's facing the death penalty, because we just know that defendants don't have the same credibility with juries as other witnesses have. And so it was my intention to show there were patterns of these behaviors and some few examples of the most egregious, and the fact that they were, for example, there were witnesses who lived in the home who could hear and see that my client was disciplined at a very early age with the use of a belt. Those witnesses could also say he was kept isolated for punishment in his room with his father and no one was allowed to go down the hallway. That's pretty important testimony and relevant. You know this testimony, Your Honor. There's nothing amazing about it. The kind of punishment, being beaten with a belt, cannot by itself cause post traumatic stress disorder, but it is terrorizing and it is fear inducing. And the fact that other people were kept away is part of the isolation. It also corroborates my client when he talks about the fact that when his father was alone in the room with him, no one else would ever was never allowed near it. Now I recognize that the court, if I understand the court's ruling, the specific witnesses who saw that will be permitted to testify. So Dr. Wilson isn't going to recite Diane Vandermolen saw this or said this, or Alan Anderson saw this or said this. He's only going to make reference to it as part of a pattern of isolating and extreme punishments. That's an example of what I'm talking about. Whether I agree or don't agree, the fact of with the court in a general sense, being a greedy defense lawyer, the fact of the matter is that we don't intend to go through this, several hundred times that we have charted. There are, however, some things that I believe the examination of our client by Mr. Khan should allow us to get into, and that very briefly has to do it really very briefly to it's really very brief to describe this accusation is how it came across by Mr. Khan that our client rejected his mother and did not attach to her and formed no bond, and that was his fault. He was some ungrateful infant, and there is evidence that is easy to summarize that he was extraordinarily attached to his mother, in fact, what constituted anxiety attachment, because his mother was spurning of him, but he pursued attachment with her. And the proof of it was how he behaved when she left him alone, left him behind, and went back east, and he was inconsolable for weeks until she finally came and got him. And that's a small fact, but I know what the people are doing. They've got this. Dr. Dietz, the master of uh, sociopathy, sitting out in the wings, and psychological research indicates to some extent that sociopathy may be caused by, the court says, let's not get into that. Ms. Amerson says, let me make the record for what I think they're trying to do by a lack of bonding in the first 6 months between parents and children. So they want to float this in order to give him some ammunition. But it's false. There was bonding, and people will say she did seem to care about him when he was very small, and he was very devoted and attached to her. And it was only later that she was spurning him and allowing him to be brutalized by the father and not interceding. But those are in response to direct things that the people tried to elicit. The court says, all right, what I'm going to do then is indicate that certainly the witness can testify as to the materials, his background, materials he relied upon, general patterns of behavior that were fear inducing this and contributed to this learned helplessness. But as far as specific examples of that, that will have to be held back for some preview of the court as to what it is that you intend to ask or he intends to volunteer. Why? Just why? Why does any of this need to be circumvented by the court? Why can't she get into this stuff? She's made such brilliant arguments, and yet he still wants to keep her from doing a proper direct examination. Ms. Amerson says, well, could we do this, Your Honor? The court says, and also, as to the biological changes, it seems to me that in your remarks, you make the leap between behavior and biological changes. Psychology is the study of human behavior. And then you're going beyond that to the biology of the brain and saying that since behavior is changes or there's demonstrative changes in behavior, that everyone knows that that's caused by some biological change in the brain. She says, I'm not making those assumptions. I'm reading the literature. Did you bring that book, Dr. Wilson? The court says, all right. The people say that they have some witness who will dispute that. Is that what you're saying, Mr. Khan? Ms. Amerson says, we have no information from that witness. He says, I'm asking Mr. Khan. Mr. Khan says, essentially, what we're challenging is the proposition that trauma causes permanent changes in the human body. There's no evidence to support that. That is what we wish to attack. And absent such permanent change, any testimony whatsoever relating to biology is irrelevant. It would be relevant only if that were true. And since it is our contention that that is not true, then any testimony concerning biology is irrelevant. Ms. Abramson says, it's interesting. It's very nice that Mr. Khan takes that position, but he doesn't have a leg to stand on. Court says, I'm not saying it's not admissible. All I'm trying to do is resolve whether it would be received now at this stage of his examination of this witness or awaiting a hearing on the people's witness testifying on the same subject. Ms. Amerson says, first of all, whether the change is permanent or only until the patient is changed is in PTSD victims, these things appear to be permanent. Now, this is the psychological theory that has guided the study in this area for 100 years. It is no more certain than the notion that there is such a thing as schizophrenia, but it is observed and it is accepted in the psychological community. Okay, there's no way to describe PTSD without describing the fact that it's changed that the theory is that has changed the central nervous system. And only I'm only going to present it as a theory. So it's no different than any other theory about psychology. The whole notion that traumatic stress causes harm is a theory like any other, and that's just a theory like any other. I'm not going to try to prove at some point what the specific biological changes that they now can measure are, but only the theory that has existed for 100 years. The court says, well, I'm troubled by, and we had that discussion with the witness when he was here. Ms. Amerson says, just one, excuse me. Court says, let me say this or I'll forget it. Court says, yeah, right. I'm sorry, Ms. Amerson says, yeah, right. The court says that if there is questioning of the witness as to changes and demonstrable changes in studies that show changes, I had questioned the witness. We discussed it and he volunteered this, I believe, in his testimony, that there were some studies that showed that you could actually study the levels of hormones or chemicals in the brain and verify this, but no such tests have been conducted. Ms. Emerson says, Judge, the reason is simple. The court says, my question is this. If the defendants have themselves not been tested, or this defendant, Erik Menendez, has not been tested, and it hasn't been verified in any physical sense that these changes occurred in him, what is the relevance of this? What does it prove? Judge, there's two different kinds of tests that happen in the world. There are those that are part of experiments in order to test these that appear accepted already based on clinical evidence and behavioral evidence, and that's the kind of tests we're talking about here. We're not talking about a blood alcohol test. We're talking about the fact that for 100 years, the psychological community has had this thesis that the interactability of PTSD symptomology and its victims may be because there is some permanent change in the settings of the central nervous system, and only later there may even be some permanent changes in the physiology of the brain itself. That's a later development. That makes this an across the board common problem of treating these folks, and the way in which they get over aroused in the sight of very slight stimuli led them to conclude with a great degree of certainty that there is something biological that's been out of whack now in these people. The tests we're talking about are these experimental controlled groups under supervised conditions with verified histories of traumatic stress who are then tested over time and sampled in laboratory experiments. And what they're finding in these tests, the testing is confirming the clinically observed theory, which is that these folks overreact because there's been interference and changes in the central nervous system, and now they're finding ways to measure it. Now, you don't measure every single PTSD person in the world to come up with this hypothesis that appears to be now being proven in this medical way. It's no different than drug trials. You don't try it on everybody before you decide this is how the drug affects someone. So that's my point. God, she argues so well. It's so frustrating that she's just met with, what's your point? How do you do this? Like nothing she says is ever taken into this court's actual, you know, thought process, I think, when he makes some of his rulings. She continues on saying, I would love to have had my client to be part of one of those groups, but he's sitting in the county jail in Los Angeles and is not available for that kind of testing. That's the problem. This is experimental testing, and you never could simply take someone in the county jail in, and I think he would never be, in this time of his life, a suitable subject for this kind of testing because of the external stressors that are happening to him right now. I mean, one of the problems always of evaluating a client who's suffering from a stress related condition when they're facing the death penalty or they're in trial and they're going to be cross examined for 15 days is the obvious problems of that. The court says, let me stop you there, Ms. Abramson. And she says, and the fact that he's on medication. The court says, has your witness ever testified on this subject before? I would have to check with him about that, Your Honor. The court says, has he given you any written reports or statements about this? No. No, says Mr. Khan. Miss Abramson says, he's a pop author, Your Honor. He writes popular books. The court says, my question is whether or not this is more appropriately the subject of rebuttal by the prosecution rather than an issue of admissibility. Mr. Khan says, well, no, Your Honor. Your Honor, we strongly disagree with that. Based upon the conversations that we've had with him, he made it very clear to us that there is no way that they can conclude at this point in time that there are permanent changes caused by trauma. This is all theory. The pop theory there is coming from that side of the table, not from the prosecution. Counsel says only 8 years ago they've been beginning to realize within the last 8 years they're the ones who are coming up with the pop novel theories. It's not us, and we filed this motion in 1994, and I realize now it's 96, but it's been on the back burner for, can I have it? Ms. Amerson says, can you read? Mr. Khan says, it's been on the back burner now for over a year. We wanted an opportunity to litigate this. We would have been willing to present this at any time if counsel had indicated that she was going to present such evidence, but she's intentionally stalled and stalled and stalled and kept us in the dark as to whether or not she was going to present this evidence. And now we're in a bind because we have a jury in the box and a court is understandably anxious to bring the jury in and get back to the testimony, and we're trying to determine how much of the evidence should be allowed. And whose fault is that? Whose fault is that? We filed our motion in 1994. We've had the witness available to come in. The fault lies on that side of that table. Obviously, he's pointing to the defense. And once again, I think it would be manifestly unfair to allow them to present the pop psychology theories until we've had an opportunity to litigate this in court. These are not pop psychology theories. These are definitely theories that have, as she said, been around for hundreds of years. Like, we've known this stuff about trauma longer than we've known a lot of other things in our medicine or in the medical sciences. So Ms. Aberson says, first of all, the people haven't had this witness since 1994, Dr. Restek. We were told about him recently when they filed their latest round in trying to block us from putting on our case. And we have been given nothing about his qualifications. He writes pop books about, the court says you were given his CV. Ms. Abramson says, right. And it shows no research in the area whatsoever. They've pointed to no research that says that the research of Bessel van der Kolk and the research of Charney and all the primary researchers in the neurobiology of trauma are wrong. I wanted to show you guys. I told you that Bessel van der Kolk, he wrote, "The body keeps the score, brain, mind, and body in the healing of trauma." And that is the book. I told you I had it. It's a good book if you guys are interested in learning anything about that. It's very, very thorough. All right. So what else shall we say here? The court says, okay, do you have some literature that you wanted to? Ms. Abramson says, tons. Have the court review? Is that what you're saying? Ms. Abramson says, I can give you all kinds of stuff, Your Honor. The court says, well, any. Ms. Abramson says, I just gave Mr. Khan one article out of. The court says, okay, I'm not asking for all the literature, just a specific thing that would be helpful to the court. Okay, says Miss Abramson. The court says, I'll review it. But before you get into this subject, I'll, at the very least, want to review your authorities on that subject. So you are going to be foreclosed from mentioning that. The biological changes in the witness will not be permitted to do so until I am satisfied that there is a sufficient basis at this point and to resolve whether or not there would be a hearing before it's mentioned or just something that people can bring out in rebuttal. Ms. Emerson says, Your Honor, here's what I'll do. We have a book that's supposed to be the most thorough and recent compilation of all this stuff. It's in my car because we just couldn't drag everything in. The court says, okay, we're going to start with the jury and then go to the other matters, and you can bring it in to me when you have a chance. Ms. Abramson says, we'll bring it to you later today. We also have some articles, and I think you'll get the sense of what we're talking about without too much. And the people can have a copy of the paper I just gave them. That's just one example of the research in this area. We have another paper that's floating around by Bessel van der Kolk called The Body Keeps Score, which is probably then what he turned into a book much later on. Okay. The court says, okay, whatever it is you're going to provide to me, hopefully it will be precise and to the point. Ms. Abramson says, it's not simple stuff, and we weren't going to get into it a great deal. The court says, I don't expect it to be simple. It seems to me if it's so accepted, then there's probably something there that would be helpful to me. Ms. Abramson said, now there is, as I see, there are two different components. One is the theory that there's biological change, which has been accepted for years, and the other is any discussion about the specific proofs, which is another issue, which is something that I don't necessarily have to do, but I'd like to. Court says, okay, the theory or the proof won't be mentionable until such time as you provide me with the literature. Ms. Abramson says, okay. The court says, okay. Ms. Abramson says, it may be difficult to describe what post-traumatic stress disorder is without discussing what they think it is. The court says, I'm sure it can be described without going into the biological theories. Ms. Amerson says, I don't know if that's true, but we'll try. Court says, and obviously, if it's otherwise admissible later in the witness's testimony, the prosecution will be foreclosed from taking advantage of the fact of what you mentioned earlier. I think there is a sufficient basis now to start with the testimony of the witness with the understanding that there will be some objections and some further discussion. Those are both understatements. We'll recess and have the jury come in, and as soon as they are here, hopefully we can get them here in 15 minutes, and we'll start with the testimony. Ms. Towery says, Your Honor, one more thing. The Sanchez case that Ms. Abramson cited, Sanchez is one of the players. The name of the case is People versus Barton. The court says, if you can provide that to me or a copy of it. Sure, says Ms. Towery. I don't know if there's an official site. The Daily Journal citation is 95. The court says, I don't have that, so we will provide one, says Mr. Gessler. Ms. Towery says, Mr. Gessler wrote on his copy, so I'll make you a copy over the lunch hour. Now a recess is taken, and they're going to come back, and we're going to get to the testimony of Dr. John Wilson, but I'm ending for the day, so I will be back tomorrow, just timing wise. It's the evening, and I don't want to read another however many an hour or more longer. So I'll be back shortly. You won't even notice, but it'll be like a whole day for me. But I'll be right back. So and then we'll continue. All right, I am back. Sorry about that. It was dinner time, and everybody, including myself and the dogs, we were all wanting some dinner. So, all right, let's get back to our testimony. Sorry for the interruption. They just had that long ass argument, and now we're gonna go to so they took their morning recess. I think that's where we left off, and then we come back. The court says everyone is present. Let's have the jury out, please. The jury enters the room. Court says the jury is in court. Good morning, ladies and gentlemen. Sorry for the delay. There were some issues that the lawyers and I had to thrash out. Sorry, there were some issues that the lawyers and I had to thrash out. Weird way of saying it. We're still in the thrashing stage, quite frankly, and I imagine there will be more delays. We're ready to start with the testimony of the next witness, who the defense may now call. Ms. Abramson says, yes, Your Honor. Dr. John P. Wilson. So he comes to the witness stand. The clerk swears him in and all that stuff. The witness is asked to spell his name. Now we've got direct examination from Ms. Abramson. Do you hold a doctorate? Yes, I do. What sort of doctorate? I have a doctorate in psychology. So, is it appropriate to address you as Dr. Wilson? Yes. And Dr. Wilson, what do you do for a living? I'm a professor of psychology at Cleveland State University in Cleveland, Ohio. I'm also a director for the Center for Stress and Trauma, which is a private corporation for the treatment of stress and trauma victims, also located in Cleveland, Ohio. I'm also a licensed clinical psychologist in the state of Ohio. And do you have a clinical practice? Yes, I do. And in your clinical practice, do you treat all psychological and emotional disorders, or do you have a specialty in your clinical practice? My specialty is in the area of post traumatic stress disorder, so PTSD. We're going to hear, I'm assuming, hopefully, a good explanation for the jury as to what PTSD is. With respect to the patients that you treat in your clinical practice and have treated in your clinical practice, are they different kinds of people? Yes. Are they all suffering from post traumatic stress disorder? Yes. And in post traumatic stress disorder, is that something that is caused by events? Yes. And we'll get into that later in some detail, but with respect to the people you have treated, do they have post-traumatic stress disorder stemming from a variety of different kinds of events and life experiences? Yes, they do. And would you describe and can you classify for us with respect to your patients the different levels of life experiences that provide those people into different, shall we say, population groups? Sure. Okay. The witness says, many of the patients that I treat come from a different type of traumatic life experiences. They include such things as war veterans, or, for example, Vietnam veterans, Korean War veterans, World War II veterans, Desert Storm War veterans. It includes victims of national and man made disasters or technological disasters. Man made disasters or technological include things like the explosion of buildings by a bomb or airplane crash or industrial accidents that are life threatening. I also treat people who have come from abusive family backgrounds where they've been the victim of some kind of childhood abuse. It may be physical abuse, sexual abuse. It also includes victims of domestic violence, women in marital relationships in which there's battering and violence or severe emotional and psychological abuse. It includes other kinds of victims as well. In the past, I've treated victims of the Nazi Holocaust, as well as many other kinds of trauma populations, including involvement with people under ongoing conditions of war, refugees in Bosnia, victims of war trauma. Most recently in Bosnia, where they were subjected to being caught in terms of the civilian population that was traumatized in the former Yugoslavia. Those are just some examples. You've spent some time in Bosnia in the last few years, have you not? Yes, I've made two trips in the past 2 years. My most recent trip was in September and October of this year for about a month. Of last year, you mean? I'm sorry, we're in 96. That's right. 95. That's right. And on those trips to Bosnia, were you also giving some crisis treatment to healthcare providers? Yes. In other words, the doctors there? Yes, part of my work, which is with the United Nations, included helping the helpers. That is, the physicians, the psychiatrists, the social workers, the refugee workers, the international humanitarian relief workers who have been involved literally in the field in helping refugees and war victims in Bosnia. They too develop traumatic stress reaction because they're trying to help those who are under ongoing conditions of trauma and warfare, and they suffer traumatic consequences as well. Now, apart from your clinical practice, where you treat people with post traumatic stress disorder based on these different events, are you also recognized as an expert in the whole area of traumatic stress syndromes? Yes. Let's go back to basics with respect to your credentials and qualifications. What is the educational background, first of all, that led you to your doctoral degree? Starting with your college degree. My bachelor's degree is in psychology, was from Baldwin Wallace College in Berea, Ohio. My master's degree and doctorate in psychology were from Michigan State University, and my most recent doctoral experience was from Harvard University in Cambridge. So take that, people. He went to Harvard to get his doctorate, which is the hardest of them to pursue. Did you start out with an interest in post traumatic stress disorder or traumatic stress disorders in general or some other area? No, I didn't start out in the area of post traumatic stress disorder. In fact, the field didn't exist during that time. I started out in two areas of psychology. One was in the area of clinical and personality psychology, which is the study of personality processes, that'd be interesting, as well as a clinical phenomenon of people suffering from emotional disturbances. I was also trained as an experimental psychologist, and this is the more scientific doing research in laboratories. It was only later in my career, around 1973 and 74, after I got my doctorate, that I became interested in what today is known as the area of post traumatic stress disorders. When did you get your doctorate? In 1973. So he's been educated for a while. He's been doing this for a while. This is 96. He's already had experience in this field. So they're trying to lay down his background because you know that the prosecution has an issue with his talking about stress and fear and stuff. So they've got to lay down his background as best they can, but that's pretty good. He's had his degree since 73. And you said that you couldn't have been an expert in post traumatic stress disorder when you started out because, quote, it didn't exist? Didn't exist by that name. There was no diagnostic category officially recognized by that particular name in 1973. Only in 1980 did the term post traumatic stress disorder become recognized and diagnostic phenomenon by the American Psychiatric Association. So took some years, but it got there. And at this point, it's already been on there for 15, 16 years. And the state and the judge both question it. This is so ridiculous. Were there, however, questions that people were found in over the years that were there question oh, 'cause sorry, were there conditions that people were found in over the years that eventually came that had different labels earlier that eventually came under the umbrella of post-traumatic stress disorder? Sure. For hundreds of years, there have been different names used to categorize a symptom or syndrome of symptoms that develops following extreme trauma or disaster. There have been different labels to go back to the Industrial Revolution, or in our country, there were labels as early as the Civil War to describe this condition. One of them, for example, was called soldier's heart at the end of the Civil War. Soldier's heart? Heart. And she spells it out Heart. Yes. And soldier's heart was a condition that now we understand and label post traumatic stress disorder? That's correct. What was soldier's heart? Objection, irrelevant, sustained. Let's move on. You can't explain that? Okay. Ms. Abramson says, let's go to your credentials and then we'll get to the discussion of post traumatic stress disorder and other affiliated ailments after that. What was your first academic appointment? Actually, my first academic appointment was before I went to graduate school. I was a visiting professor of psychology at the University of Tennessee in 1969. And after you received your master's and doctorate, what were your academic appointments? My first appointment was as an assistant professor at Cleveland State University. That's where I still am. And from there, I went to be associate and full professor in 1980. I've also been a visiting professor at different schools, including Michigan State University and the Royal Brisbane Hospital and University of Queensland Medical School in Australia. I was wondering that when I heard Brisbane, however you say it. Um, yeah, so that he's been teaching at all sorts of different places, among other places where I've been a visiting professor. Have you spent a great deal in Australia through family connections there? As well as professional, correct. And any other positions and academic appointments that were significant in developing your expertise? Those are the primary ones. You've been a full professor since 1980? Yes. For 16 years? Yes. As a full professor, do you supervise doctoral candidates? Yes. And do you do that just at Cleveland State or at other universities as well? I do it at at other universities as well. What other universities do you supervise doctoral candidates? I supervise doctoral candidates at the Union Institute, which is located in Cincinnati, Ohio, also here in California from the Fielding Institute, which is based here in Los Angeles. I have in the past supervised doctoral candidates at the University of Massachusetts, and I also supervised a doctoral thesis that was a combined doctorate from the Catholic University of the United States and the Vatican in Rome. Hmm. That's interesting. He teaches all over. What was the why does the Vatican need to know about trauma? I guess maybe so priests could better help people who've been traumatized in their churches. I don't know. I really don't know. Maybe that's the only thing I can think of, but the Vatican also wants his teaching skills. Well, what was do you supervise doctoral theses solely in the area of post traumatic stress disorder or in some other area as well? Primarily in the area of post traumatic stress disorder. Now, have you received research grants over the years for working in the area of post traumatic stress disorder? Yes, I have. And if you would name, there's quite a few listed here. Why don't you name the most significant ones? There have been a number of them. The first one I received is from the Disabled American Veterans, which was a research grant from 1976 to 1981 And it was to look at the readjustment problems of returning Vietnam veterans. Since that time, there have been numerous other grants. My most recent one was that I received was a grant to study the psychological traumatic consequences of mental health in medical providers in the former Yugoslavia and particularly Bosnia. This guy gets around, man. He's a good witness. You told us a little bit about that, and you had a grant to work. I currently have a grant and actually have conducted the first phase of the study. And have you had a series of grants having to deal with studying Vietnam veterans? Yes. How did you receive any graduate fellowship during the course of your education? Did you receive any graduate fellowships during the course of your education? Sorry. Yes, I had a number of graduate fellowships that enabled me to attend graduate school on a scholarship. And that was based on merit, correct? Correct. How about honors you have received since how about honors you have received since receiving your doctorate? I've received a number of honors. Would you just mention a few of the ones that you were most grateful for, if you will, or thought the most of? Yeah, I would be happy to. The ones that I'm most grateful for the ones that mean the most to me are National Commanders Awards from the Disabled American Veterans for my work with Vietnam veterans. That was awarded to me in 78 and again in 79. In 1979, I received two awards that are super special to me. One was a President's Accommodation from President Jimmy Carter, and that was an accommodation that was given to me by the president for my work with Vietnam veterans. That's pretty cool. An award from Jimmy Carter. That was the dude before Reagan, if anybody is really young and doesn't remember. Jimmy Carter was president when I was born, but then he left shortly after, and then Reagan was. But Um, anyways, that'll give you an idea of how old I am. So, so that's cool. He got this accommodation from the President of the United States, in particular in designing the National Readjustment Treatment Program for Vietnam veterans during the Carter administration. So he designed a national readjustment treatment program for veterans to readjust blah, 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 back into society, if I could talk. Anywho, yeah, society. So it seems like he was doing some good work with the veterans there and created a national sensation. And at the time, I received in 1979 the George Washington Honor Medal from the Freedom Foundation at Valley Forge, and that was similarly for my work with the Vietnam veterans. That's also very cool. More recently, there are two others that I care about a lot. One was from the American Red Cross. It was called the Vega Award, which is their highest award for service to the Red Cross that was given for work I did as a volunteer for Red Cross commanding an emergency team that responded to the U.S. Air 405 crash at LaGuardia Airport. And it was our emergency team in Cleveland, Ohio that went to LaGuardia to help the families and the survivors of the crash. That seems pretty cool. Similarly, I received an award following the Gulf War from the American Red Cross for the work I did during the Persian Gulf War, also the Vega Award. Those are some of the awards I received that mean a great deal to me. And when you say you were part of an emergency team that you immediately went to LaGuardia right after the crash, this response was twofold. I was chairman of emergency services for the American Red Cross chapter in Cleveland, so that plane from New York was Cleveland bound. U.S. Air 405 was a Cleveland bound plane from LaGuardia, and as you probably recall, it crashed on the runway while taking off and killing half of the passengers. So, what did it crash into on the runway? It crashed on the runway into something. So our team deployed immediately in Cleveland. Half of the team stayed in the Cleveland area to console and assist the families waiting for loved ones to arrive from New York. And the other half of our team was deployed immediately to New York to assist two groups of people. One was the U.S. Air Corporation that was in enormous distress about what had happened, and number two, to assist the families and survivors of the crash. And at that point in time, when our team deployed to New York, the status of the survivors or victims was unknown, and so our work was to coordinate with the police, fire, and morgue department of Queens, New York, where LaGuardia is located, to determine the status of those who were involved in the crash. And that team stayed in New York for about 2 days and then returned in Cleveland, where we continued to assist the survivors and families for a period of about 2 months. What is the reason why someone who's an expert in post traumatic stress disorder would be dealing with families and victims immediately after a national disaster like this or a man made disaster? I'm not sure what caused the crash. It was weather-related crash. So a natural disaster then. Well, in any case, sorry, he says, in any case, the reason we responded was twofold. One, as Red Cross volunteers, you are mandated to respond to disasters. And number two is we understand clearly that people who have been or who have had severe traumatic experiences when they receive immediate intervention and care are less likely to develop more disabling or more troubling psychological or psychiatric consequences when they have intermediate intervention and support following this kind of catastrophe. Well, the same thinking, as far as you know, behind providing psychologists and mental health workers immediately to the survivors of the Oklahoma City bombing, for example. Yes. Or children, where there's been a shooting at the school or classmates have been killed in bus accidents, like things like that. Yes. What is the reason why that immediate intervention, I assume there's a theoretical framework for what is immediate intervention for stopping a catastrophe from happening? It may not stop a lot of things from happening, but the point of the immediate intervention is one, people following catastrophic trauma are usually overwhelmed, dazed, confused. Their world is often immediately shattered by their experience because it happened unexpectedly, often unexpectedly. And the consequences are horrific to people who either survive or the relatives of the survivors who have to view the aftermath of the disaster. So by intervening immediately with support, you put it in a put you put in a cushion to put in a buffer that helps insulate the person from other kinds of stress that impact on their life. What kind of buffer or stress? What cushion? I don't know what he's talking about. Secondly, you could step up a process of normalizing the stress response. Many people don't know that when they go through a trauma, there is predictable sequence of stress responses that occur. These include being overwhelmed and dazed and numb, and then beginning to relive the trauma or being unable to sleep or to have certain changes in one's physical state, such as being keyed up for hyped, aroused, or um, unable to concentrate, and so on. So, the idea of rapid interventions to help the person to process their immediate reactions if they're the survivor of a loved one of the survivor, to come to understand what is the common psychological response pattern to those who have been traumatized, so that when you can put into place in a normalizing sequence which maximizes the positive outcome for those who have been affected. Didn't understand it. Half of that. Let's see if we can cut through a little bit of that language to explain in terms simply for like me to relate to. Like, I'm not a doctor. Can you just tell me like you were talking to a patient, like they don't understand medical terms? Let's say you have a relative, let's say you're a wife and you have a husband who was on an airplane and that plane crashes. Now you don't see the crash, right? But what you do see is you get there and your husband's severely injured, is in the hospital, and you don't know if he's going to survive. Now, is my hypothetical woman a candidate to develop post traumatic stress disorder? Possible, yes. Are you saying that if you let me know as this hypothetical woman what the stages are, how people react to these overwhelming, unexpected stresses, and what kinds of things to expect, what I can deal with it, then I can deal with it better when it happens or stave off from occurring? He says both. You can stave it off and you can deal better if and when it happens, partly because you have information about what's likely to happen. That's the important thing about explaining stress response syndrome to trauma victims. It gives them a sense of control. They don't have to fear that they're going crazy or losing their mind. They understand that is a normal reaction to an abnormal event. It allows them to talk about it, allows them to understand, and what they're feeling and experiencing is perfectly normal, and there's nothing abnormal about it. That's salutary, that's beneficial, that helps a person to cope. Now, for the Vietnam War veterans, just to pick one group of people that you have treated, and you're not the only person in the United States who has treated or who has studied post traumatic stress disorder with respect to war veterans, are you? No, fortunately, there are now hundreds that are doing that and have done that for about 2 decades. So the science isn't new. This basic, like this theory isn't new. This is all stuff that they've been in the works for 200 years, or sorry, not 200, 20 years. 20 years. With respect to those Vietnam War veterans, during the time that the post traumatic events were occurring, which I assume are some of the events involved in the war that you were part of, were there mental health professionals there to try to help you cope with what might happen to them? No. Objection, irrelevant, overruled. The answer is no, says the witness. Ms. Abramson says, and did many of these war veterans come back home from the war and start experiencing symptoms of trauma and what not only what happened caused it or what was happening to them? Not no. What did I say? Not no. I don't know what I said. I'm sorry. The answer is yes. The research that my brain just doesn't work. So I apologize when I slur my words and things. And it's like I'm seeing it on the paper. I'm either seeing the word that I think I'm supposed to see and I say the wrong word, or just the wrong word just comes out of my mouth and I'm seeing the right word. And this is what happens when you have fibromyalgia, ankylosing spondylitis, POTS, and who the hell knows what else I have. Started the day out with a migraine too, if that means anything. Maybe I'll go get a cup of coffee. My migraine's gone, but the caffeine will keep it away, I think. I'm back with coffee. Usually coffee helps my brain function a little bit better, a little faster. So hopefully we can get through this. All right. So Ms. Abramson's question was, were there people that came home from the war and they had experiences of trauma and then they didn't understand what was happening to them? And he says, yes. His answer is yes. The research that we have shown that about 80% of returning Vietnam veterans develop some symptoms of post traumatic stress when they return from the war, but never talked about them with anybody whatsoever. And by virtue of the fact, my dog likes coffee. He wants some. uh-uh. Mm, I can't drink it. He's trying to spill it on me. By virtue of the fact that they never talked about it and they didn't receive any intervention, did they get worse? Yes. And were their lives seriously impacted by their reactions to the traumatic events of the war? Objection, irrelevant. And the court says, you're talking about 80% of all those veterans? Are you talking about some? What are you talking about? Ms. Abramson says, let me back up. 80%, you said some had symptoms, had not talked about their experiences in the war. 80% of the ones with symptoms had not talked about their experiences? No. In general, for the whole population of men that served in the war, 80% when they returned had not talked about the experience of the total population. About 80% of all military personnel had symptoms of that syndrome. I'm not saying they were disordered, but they have the development of symptoms following their war experience. Is there a notion now about percentage of the returning Vietnam vets actually developed full-blown post-traumatic stress disorder? Yes. What percentage is that? About 26.5% had a lifetime diagnosis of PTSD, post-traumatic stress disorder. And with respect to the others who had some symptoms, what resolved those? Are there studies as to what happened to that group of men? Sure. And women, what happened to them? Well, that's a big question that maybe the simpler here answer is like this, that those who had the most support coming home, intact families, an opportunity to access VA hospitals for medical and psychiatric care, the opportunity to go to the clergy or private mental health practitioners, as well as the opportunity to speak about their experience meaningfully to somebody, tend to do better. That is, they're less symptomatic, less likely to suffer emotional and long-term consequences of the war trauma in Vietnam. So they are doing better? Yes. With respect to the 26.5% who have a lifetime diagnosis of PTSD, are all of them in treatment? No, not all of them are in treatment. There's a significant number that are currently in treatment throughout the VA systems throughout the United States. However, and what is the, if you know, success rate for the treatment of that group of war veterans and post traumatic stress disorder? Objection, irrelevant. Overruled, says the court. The witness says, at this time, the success rate isn't known. Why is that? Says Ms. Abramson. The witness says, because there have not been enough psychotherapy outcome studies to have an accurate number to tell us of those who go through the treatment programs in the specialty units of the Veterans Administration, how many of them have a remission of their symptoms, and how many of them have a recovery from their severity of their stress disorder. And with respect to your clinical practice, you are still currently treating Vietnam War veterans? Yes. Who still have PTSD? Yes. That interfere with their life enough to bring them to therapy or keep them in therapy. They're non functional, they don't work. So sometimes it can be so bad that you can't function in society. And the war ended when? The last U.S. troops pulled out of Vietnam in 1973, proving that PTSD is long term and time away doesn't necessarily make it better or make it go away. Because we're talking now 1996, he's still treating people from the Vietnam War, which lasted or it ended in 1973. So we're talking about 23 years later, longer in most cases, he says. Of these of these were people who were in combat in the 60s. Correct. Were these people in general, as a general population, the people who developed post traumatic stress disorder first from the wartime experience, people who were abnormal or mentally ill going in? No. So they were not experiencing emotional distress before they went in. Is post traumatic stress disorder something that helps or that happens, sorry, to people who are abnormal? It can happen to someone who's abnormal, yes. Are those the only people whom this happens to whom this happens? Okay, she's all good English and everything. She's like, "Are those the only people to whom this happens?" Yes. Does it happen to normal people? Usually, yes. In other words, people who have no other mental illness, disease, or defect? Correct. It could happen to anyone? Yes. Now, apart from the war veterans, before we get to that, let me just ask you, I asked you the sort of pat yourself on the back question before, are you an expert, and how does one become recognized as an expert in a particular psychological subspecialty such as the treatment and research of post-traumatic stress disorder? It says the customary way is one either generates research, that is, publishes articles in journals or writes books, or does similar contributions to the field, such as helping to discover a condition or define an illness, or make a discovery about a particular phenomena. That's one way. Another way is I think people develop expertise for having done innovation. For example, in treatment programs for a particular kind of disorder that might exist, such as PTSD or some other condition, so that within the scientific community of peers, there's recognition that one is an expert with knowledge and expertise and competence in that particular phenomenon. How did you become an expert? What methods, what what pathway led you? I think the pathway that led me, and I'm a little uncomfortable talking about this. You're asking me to toot my horn. She says, I know, toot it quietly. He says, I'm trying to. Very simply, I did one of the first research projects on Vietnam veterans in the United States, and it led to the definition of post traumatic stress and also led to my involvement in the Carter administration to help. Holy crap. He initiated basically PTSD research, the first of its kind on war veterans. And not only defined the disorder, so it entered into the diagnostical manual, the DSM 3. So, this is how long ago this happened because we're on the 5 now, so DSM 3, but also became recognized by the Congress of the United States as a significant mental health problem for returning Vietnam veterans. Guy has some creds. He's got street cred, you know? He has some street cred. So all that gobbledygook from the prosecution and their arguments as to why Dr. Wilson can't testify about PTSD and things like that, totally off base. This guy is like the inventor of PTSD almost. Now, besides doing the first research project, have you done others? Yes. How many research projects have you been involved in the area of post-traumatic stress disorder? It's not only PTSD, is that correct? Correct. There are others? Right. How many research projects have you done in the area in general of PTSD or traumatic stress disorders? I don't know, over a dozen anyway. Have you also, that's a dozen research projects where that you're in control of, you've designed and executed? Sure. And then when you do one of these research projects, do you write about it? Yes. And have all your research projects been written up? No, I have several currently underway at the present time. Well, with respect to all of those that are completed, though, were they then written up? No, they're not all written up either. There are a lot on the burner. You're overloaded, I gather. You got it. I like this guy. So you publish and have you do you publish and have you published scientific papers, books, articles in the area of PTSD? Yes. And traumatic stress syndromes? Correct. Have you testified, in fact, in front of Congress on post traumatic stress disorder? Yes, on 6 occasions. What the hell is in Mr. Khan's panties that he is so like, does he have a wad up his ass? I mean, seriously. This is crazy. This guy is insanely qualified to talk about PTSD. The whole thing about not wanting him to talk about it because he's not qualified and all that BS. Garbage. It's garbage. He's like the inventor of PTSD, and he has taught Congress about it. So there's that. But yet he's not a good witness, and we can't trust him. And all the things he says are just gobbledygook. And we have a witness. Trust us. We have a witness that'll say otherwise, but we haven't told you anything that they said, and we haven't given you any of their work. But just trust us. We have another guy over here that's going to say that your guy is full of garbage. That's basically what the prosecution is doing to try to prevent the brothers from defending themselves. It's ridiculous that this stuff is so like taboo in this year, in this time. Like, I know this is a long time ago, but it doesn't really seem that long ago, and it was taboo at the time. But this is insane. This is crazy to me that Judge Weisberg went from allowing most of this stuff in the first trial, and now in the second trial he doesn't want it in, and he fights the defense constantly on all of the issues that the prosecution brings up. So it feels almost like the prosecution and the state are teamed up against the defense teams, and it's not fair. It's really annoying. Anyways, let's move on. So, have you testified in fact in front of Congress? Yes, 6 times. Have you consulted to various organizations on traumatic stress syndromes? Yes. You have a list of, it looks like, about 25 different organizations? Yes. Would you just pick out the most notable? Most notable? World Health Organization, the United Nations, U.S. Congress, U.S. Senate, the White House, Veterans Administration, National Science Foundation, National Institute of Mental Health, United States Army, United States Navy, United States Special Forces, American Red Cross, International Red Cross, the Commonwealth of Australia, Division of Mental Health, the Commonwealth of Australia, Division of Veterans Affairs, the European Community Task Force, the U.S. Task Force on Humanitarian Aid to Bosnia. The court says the Department N of the Superior Court of Los Angeles. The witness says, would the record please add that? Thank you. And Department N of the Superior Court of Los Angeles. I have no idea what that means. Did he do training or something for the Superior Court of Los Angeles? Or is that a joke? I have no idea. Missy Abramson says, we're still trying to figure out here if Elvis is still alive. So this is a joke, I guess. The witness says, I just saw him on the corner on the way here. So he has a sense of humor as well. He just saw Elvis on his way to court. Ms. Abramson says, okay, you've answered the question. I want to show you a red book that I'm not going to mark as an exhibit at this point, but we were going to refer to it. Do you know what this is that I'm holding? He says, she's holding the DSM-4, which stands for Diagnostic Statistical Manual, 4th revision of the American Psychiatric Association. And I'll put it in front of you in case I don't think you've got it totally memorized, but what is that thing and what is it for? The DSM-4, remember we're on 5 now, so times have changed, but the DSM-4 is a kind of Bible of mental disorders of the American Psychiatric Association. What it contains are codification or classifications of all known mental disorders or clinical disorders that are the attention of mental health professionals. That includes psychiatrists and psychologists and social workers and others. It's a book that's used to aid in the diagnosis of psychological and psychiatric conditions. It's a book that's used to aid and guide research in the scientific community. It's a book that's used educationally to inform, for example, students in learning situations about classifications and knowledge about mental disorders. It's a book that's also used for legal purposes, but for example, in terms of insurance reimbursements in our system, healthcare benefits. It's a book that would be used in forensic or adjudication settings as well, determining disabilities. For example, for someone who might have a particular illness that isn't listed in the manual, those are the general purposes for the manual. And when you say it codifies and classifies mental health disorders, does it start out by defining them? Yes. And who decides what the definition is for a particular mental disease or disorder? Who decides, basically, is the committee of people who evaluate the scientific literature and who are charged with the responsibilities of defining each of the conditions that exist in the book. So, to say it in the simplest terms, it's a scientific peer community. When you say they review the scientific literature, they don't just sit down and say, let's make up a definition, say for schizophrenia, that we are individually comfortable with. No. They're supposed to look at all the research and treatment and knowledge and experimentation of the entire scientific community to come up with accepted definitions for each and every mental disorder that's understood to exist. Correct. And is everything that makes people say get psychiatric or psychological treatment necessarily a mental disease or disorder or syndrome? No. Do people seek psychological help and counseling for things that they're not really classifiable in that book as suffering from known mental problems? Let's just keep it general for the moment. Sure. Is, however, the body of scientific literature that, as you said, the codification and definition classification in that book, does it originate in the problems that people have psychologically? Yes, of course. So that book contains some things that are understood and have been understood for a long time to be very serious mental illnesses, correct? Objection leading, overruled. Yes. Ms. Abramson says things like schizophrenia, for example. Yes. Does it also contain things that are understood to be psychological conditions that are not per se serious diseases? Yes. Does it describe things or conditions that people suffer from who are not crazy? Yes. Who are not mentally ill? Correct. As well as things to which we would affix those phrases, crazy and mentally ill? Yes. All right. Is this what you were talking about when you said until 1980 there was no definition of PTSD in the DSM, the Diagnostic and Statistical Manual? Is that what that stands for? Yes. That was a compound question. So what was he answering yes to? There was no definition per se in that book, not until 1980. And you've indicated that this is the fourth edition book from this book. From one published edition to the next, are there sometimes changes made in the specific description of various mental disorders as well as the addition of new ones? Yes. And when a new one is added, does that indicate that suddenly different things are bothering people or there are different kinds of problems that people are having, or is it just a new understanding or something that's been around for a while? I think you could say it's a new understanding. When post traumatic stress disorder was included inside the 1980 version of that book, was it assumed what was being codified and described was actually something that had been around for a very long time? That's correct. So it's just being identified by a name, but it's been here for a while. So PTSD has been around for a long time. It just now got a name. That's all. It's being classified as PTSD from here on out until maybe one day they change it again. Who knows? Did that thing that had been around for a very long time have different labels in the book? Did it appear in the book at all? Yes, under different labels starting in 1952. So, just starting in 1952, what were some of the labels that encompassed what later became to be codified? It's called for short PTSD. Correct. Okay, that came to be labeled in 1980 as PTSD. That's right. What were some of those, just briefly, some of the things that appeared in the book under different labels that eventually came to be subsumed under PTSD? The specific categories in 1952 were called gross stress reaction, and that was a codification that encompassed much of the same language that appeared in 1980. The second version of the manual occurred in 1968, and in that revision, gross stress reaction was changed to a different label, which was called transient adult situational personality disturbance. Let me say that again: transient adult situation personality disturbance. That was easy. Yeah, it's a long sentence full of words. What is implied was a short term reaction to a condition. And then in 1980, after the 1968 revision, post traumatic stress disorder was classified as its own diagnostic entity under the general rubric anxiety disorder, which had a number of subcategories, and post traumatic stress disorder was one of the anxiety disorders listed in 1980. Now, there have been subsequent revisions. In 1987, there was a DSM 3R, but the title remained post traumatic stress disorder. In 1994, there was another revision, the one which continued the diagnosis of post traumatic stress disorder, but also added another subdimension under the anxiety disorders called acute stress disorder, and that characterized the onset of acute stress symptoms following traumatic or life threatening experiences that had the onset of the symptoms and the offset of the symptoms within 1 month. But if those symptoms persisted beyond 1 month, then the diagnosis changed from acute reaction to post traumatic stress disorder. Post means after? After. It means after. An external causative event that involved traumatic stress. Yes, but it means more than that. Literally, the word post traumatic means post injury. The origin of the word trauma comes from the Greek and Latin and means injury, and usually means external injury to the body that has both physical and psychological consequences. Is it necessary for someone to have a physical injury to the body to experience post traumatic stress disorder? No. In fact, people involved in earthquakes who are not harmed in any way, a certain percentage of people will develop PTSD, correct? Correct. And the example we had of the woman who wasn't harmed, but whose husband was in the plane crash, and she could develop post traumatic stress disorder even though she wasn't in the plane crash? She could. And healthcare workers in Bosnia who could be developing post traumatic stress disorder, they're not hurt? That's right. And refugees haven't necessarily had injury, but they're in the middle of a war. Correct. And in fact, with respect to the Vietnam War population, those veterans were all of the veterans who developed post traumatic stress disorder injured. Were all of them injured in the war? No. Apart from publishing the results of your research projects, have you also written a lot? Yes. In this field? Yes. Can you give us an idea of how many publications in the area of post traumatic stress disorder or traumatic stress disorder you have written? Well, in terms of scientific presentations, it's probably over 250 at this point. I'm currently finishing my eighth book on post traumatic stress disorder, which will be published in a few months. And I've written numerous articles in scientific journals. And you say you're writing your eighth book. What have you also edited books? Yes, regarding PTSD or post other traumatic stress disorders. Yes. Are you editor of the International Handbook of Traumatic Stress Syndromes? You, John P. Wilson, and Beverly Raphael. That's correct. And is that basically what it is, the International Handbook for use by professionals concerning traumatic stress syndrome? Yes, this book has been adopted around the world. It is the book adopted, for example, by the United States in Bosnia as well as elsewhere. Now, you indicated that in your clinical practice, some of the patients that you treat are suffering from either full blown post traumatic stress disorder or some of the symptoms of PTSD as a consequence of domestic violence or child abuse. Yes. Is there a body of literature? I've talked about your contribution to the body of literature having to do with PTSD, correct? Correct. Are there other people besides yourself writing in the field of post traumatic stress disorder? Many of them. Do you have an idea of how many articles or books are being written by people involved in the field, psychiatrists, psychologists, and social workers and others for psychiatric journals? I don't mean about for Newsweek. Uh huh. So, scientific journals concerning post traumatic stress disorder alone. Uh huh. Yes, I do. Okay. How many? Let me explain the answer specifically this way. There is a national database that charts this. It's called the Published International Literature on Traumatic Stress, and it's based in New Hampshire, and it's funded by the United States government. And one of the national PTSD centers is Pilots. Published international literature on traumatic stress. Pilots has an ongoing computer that monitors every publication in the world on post traumatic stress disorder, and virtually anybody who wants can tap into it. Huh? What other little things like this does the government have that we don't know that we're being spied on? Um, okay. So the point is, there's over 8,600 published articles on post-traumatic stress disorder in the National Pilots database. To answer your question about how many per year is hard to answer because the curve continually changes. We know it's an accelerating curve. It gets more and more every year. A conservative estimate would be worldwide there's now about 500 articles plus per year in various journals throughout the world on post-traumatic stress. And if you add into that the number of books that are published per year on post traumatic stress, there's an average of about 3 to 4 books per month being published with reference directly to post traumatic stress disorder. 3 to 4 books a month being published. That's like a book every week. That's crazy. All right, or every month. I'm sorry. I meant every month. Um So, for anyone in the mental health field who wants to learn about and understand post-traumatic stress disorders and the people who tend to get them and the treatment modalities and an understanding of why it occurs and how it works, there's a ton of literature out there from which to learn. Not only for mental health professionals, virtually anyone who has a computer and modem can tap into the system and access that database right now. Will they be able to understand? Let's say anybody in this classroom within the bar. We don't know who that's out there. Yeah. Is it the kind of thing that any layman can read and understand? Absolutely. That's one of the beautiful things about the database because those articles not only give you research, they're annotated. So on your computer screen, you can scroll down and it will give you the scientific research and then an annotation, which is an abstract and a description in straightforward language of what's contained in that article. And anybody in this classroom can do that. Court says the 17 people there will not be doing it. Ms. Abramson says they're not going to bring a computer. The court says, as they're aware, they will make their decision on the evidence they see or hear in the courtroom. The witness says, I wasn't suggesting that. Ms. Abramson says, I understand. Or, I'm sorry, the court says, I understand. Ms. Abramson says, okay. But certainly anybody in the mental health field knows this is well known that this huge database exists on post traumatic stress disorders and can be accessed. Yeah, it not only exists in pilots, there are two other databases just to be complete. One is indexed Medicus, which is what doctors use. It accesses all the medical journals, and likewise, with a computer and modem, you can access this medication. And, Your Honor, as you know, for forensic and legal purposes, there's Lexis and Nexus and Westlaw, which are the three databases for the legal profession They too are now codified for post traumatic stress. So, any issue pertaining to post traumatic stress disorder is in legal or forensic Lexis or Nexus and Westlaw now is cross indexed with post traumatic stress disorder, and that's also cross indexed with the pilot database. So, you have all three databases to work from. Now, is there also a parallel body of research? Well, maybe not parallel. Is there both a parallel and crossover body of research? Strike that. Let's back up. Within the body of literature dealing with post traumatic stress disorders, is there literature dealing with different population groups, people, and situations where post traumatic stress disorder is a common outcome? Sure. So, within that literature, is there literature about war veterans and the treatment of war veterans and how and why post traumatic stress disorder develops among war veterans, as one example? Sure. And what are some of the other groups where there is specific research and literature dealing with post traumatic stress disorder in groups of people? What are some of those examples? There are virtually hundreds of them, but the big one would be war trauma, national disaster, technological disaster, childhood abuse, the R word, trauma, and sexual assault or domestic violence pertaining to post traumatic stress disorder. And then you can go on from there. So I'd say Eric and Lyle both fall into many of these categories. Child abuse, yeah. That's like three categories that they could kind of qualify for there. In going on from there, if is there also reference to the psychological field dealing with the effects of child abuse, child sexual abuse, child physical abuse, child psychological abuse, domestic violence, and battering, where the person doesn't necessarily develop post traumatic stress disorder, but does suffer from psychological consequences for those battering and abusive relationships? Yes, that does exist. Is there a very large body of literature, in fact, dealing with domestic violence and child abuse and the psychological effects of those things? Yes. And that's in addition to the post traumatic stress disorder literature? Correct. Is there a cluster? Strike that. Do we define? I mean, do we, not do we, do you also define these outcomes of these traumatic events in terms of the symptoms that the people develop? Yes. So when we're talking about the DSM-4 and we're talking about the codification or the definition of post-traumatic stress disorder, is it in fact a list of the symptoms? Yes. And with respect to the accepted research and literature in the areas outside of post-traumatic stress disorder dealing with child abuse and domestic violence like battered women, battered people, are these clusters of symptoms that define the effects of child abuse and domestic abuse? Yes. And do some of those listings or clusters or symptoms get grouped together under some definitions? Sure. And is it one of those definitions, battered women syndrome? Yes, it is. Objection irrelevant. Overruled. Yes, it is, says the witness. Is another of those definitions battered child syndrome? Yes. And is a third definition battered persons syndrome? Yes. Now, do those syndromes, which I think you've just told me is a listing of clusters, groups, or of symptoms, do they appear as mental disorders in the DSM-4 the way that post-traumatic stress disorder appears? No. Why not? Because one could develop symptoms, for example, through grape trauma syndrome or being a victim of domestic violence or being a child in an abusive family and have some of the symptoms of post traumatic stress, but not all. You could have other symptoms. So you might not meet the full diagnostic criteria for a particular diagnosis in the manual. It could be post traumatic stress disorder or some other diagnosis. Still, you could have consequences in terms of symptom development following those experiences. Well, I think I was asking more basic questions. Who decides whether battered women syndrome, for example, should be in that manual or shouldn't be? It's the committee that makes the decision on what classifies a mental disorder and where would it fit in the manual. Is it a political decision, or, in other words, if there's clusters of symptoms that can be called battered women's syndrome, would it somehow violate the basic rules of what the DSM is for to put in there? Not at all. Is this something that's been debated, in fact? It's been debated now as we speak. It's being debated now as we speak. There's committees that are undergoing this kind of process of evaluating what the next revision of post traumatic stress will be, and it includes this very discussion of battered women syndrome, battered person syndrome, child maltreatment, the effects of domestic violence, and how and in what way the definition of PTSD should be expanded. There's already been publications, for example, on what's known as complex PTSD. Dr. Judith Herman at Harvard Medical School has written rather extensively about that. I wouldn't say it was political. I would say it this way. It's an ongoing revolutionary process in terms of understanding how the knowledge base scientifically expand so that decisions can be made about how to interpret thousands of this new data that emerges from different traumatized populations, whether it comes from domestic violence or from war veterans or abused children or victims of, say, technological disasters such as Chernobyl. Getting back for a moment, would it be fair to say that the broadest label, because it doesn't distinguish race or discriminate based on age or gender, is battered person syndrome to talk about the group of syndromes? Yeah, if you're talking about acts of interpersonal violence or acts of interpersonal exploitation, acts of psychological or physical or emotional harm, yes, I think those kinds of interpersonal acts, which in terms of domestic violence or interpersonal relationships best fall under that kind of rubric of psychological maltreatment or battered person syndrome. Okay, well, battered person syndrome, if as a clinician or as a researcher, there's a population of people that are studied who have had history of being harmed by another person, we'll strike that, take away history. Let's say persons who have certain symptoms and report a relationship with another person which has traumatizing features. Is that what classifies that person as suffering from battered person syndrome? Yes. So, if you have a woman, for example, who's been in a marriage and she has been hit, controlled, terrorized, demeaned, imprisoned, stalked, dominated, degraded, all that different range of behaviors by her spouse and has developed symptoms as a result, that's a person who might fit the category of suffering from a cluster of symptoms that comprises the battered person syndrome, right? Objection leading. Overruled. The witness says yes. So, whether someone is classified as suffering from battered person syndrome or from post traumatic stress disorder, which is the most formal recognized mental disorder, are you talking about the same kind of thing that happens to people, just to generalize, who are treated badly by someone else? Yes. Just to race ahead for a moment, did you perform an evaluation of Erik Menendez in this case? Yes, I did. And as a result of your evaluation, the details of which we'll get into after lunch, did you form a diagnostic opinion concerning him? Yes. First, let's start out with, do you have a diagnostic opinion concerning him right now as he sits here in this courtroom? Yes, I do. With respect to right now, do you have an opinion as to whether he suffers from any mental disease, defect, or disorder? Yes, I do. And what is that opinion? It is my opinion that he suffers from chronic post traumatic stress disorder. Now, based on, again, your evaluation of him and all the materials, which we'll get to, that you examined and evaluated, do you also have an opinion as to whether or not he suffered from a mental disease, defect, or disorder on August 20th, 1989, at the time that he participated in killing his parents? Yes. And what is that, if you know? My opinion is he suffered from post traumatic stress disorder, chronic. By using the word chronic, Do you mean to imply that this wasn't a short term 30-day thing? Correct. And do you have an opinion as to at least a range of how long before August 20th, 1989, Eric Menendez was suffering from post traumatic stress disorder? For many years. Mr. Khan says, I would move to strike as irrelevant and non responsive. The court says, all right, the answer will stand. Overruled. Well, at least that's good. Ms. Abramson says, now, do you also, in evaluating all the information that was presented to you, have an opinion as to whether or not at any time in his life, Eric Menendez suffered from battered person syndrome? Yes. And what is that opinion? My opinion is that he suffered from battered person syndrome. Does he suffer from that now? Yes. Did he suffer from that on August 20th, 1989? Yes. Did he suffer from that for a period of years preceding that date? Yes. And did you also form an opinion as to whether there were any additional components to his mental state now? I'm not sure what you're asking. Is there a mental condition known as depression? Yes. Is depression a mental illness, disease, defect, or disorder? Yes, it is. And is depression necessarily part of the post traumatic stress disorder? Not in every case, no. So, are there people who suffer even chronic post traumatic stress disorder who do not suffer from depression? Correct. Do you have an opinion or do you have an opinion as to whether or not depression is or was an additional psychiatric condition or mental condition of Eric? Yes. And why don't you tell us what that opinion or opinions are? My opinions are that he has also suffered from depression as a comorbid condition with his post. Well, that's a word that's bound to confuse. What do you mean by co? At the same time that he has PTSD, he also has depression. Thank you. So the comorbidity means you have two things at once. Currently, I see that as depressive symptoms are somewhat in remission, especially because he's currently under medication for depression. So at the present time, I don't see him suffering depression as he did prior to the onset of taking his medication. So he's taking medication, it's now helped. So it's better than when he first met Eric. Depression is a condition that for many people is treatable with medications. Yes. And you're familiar with the medications that he's taking? Yes. Are they specific for depression? I don't know if you guys can hear that. My dogs are playing. And now they're bumping into me. Um, Sorry, what was the question? Are the drugs that he's taking, are they specific for depression? Sorry about that. They were banging into me. The drugs he says are for depression and anxiety, correct? When you say something is in remission, what do you mean by remission? We mean that the symptoms have abated from its previous conditions as its previous level. It may not be present at that time, but it was present in the past. It might not be present currently, but it was present in the past. With respect to the past, was one of the things that you examined before you reached your conclusions about any of these diagnoses that you have given us the notes of examinations and interviews prepared by a forensic psychiatrist, Dr. William Vickery, who also testified in the first trial, concerning his contacts with Eric Menendez over the past 5.5 years? Correct. So he's reviewed all of that stuff from William Vickery, too. Based on your examination of the materials from Dr. Vickery, does it appear that at the time Dr. Vickery saw Eric Menendez, Eric was not medicated? That's correct. Is it your understanding Dr. Vickery was the first psychiatrist to prescribe medication for Eric Menendez after Eric's arrest? Correct. Does your diagnosis that Eric Menendez suffered from depression, which is currently in remission, does that consider the observations made by Dr. Vickery at the time that he first started treating Eric? That is correct. In addition to reading the notes of Dr. Vickery, did you also read the testimony that he gave in this first trial? I did. And in Dr. Vickery's notes with respect to the issue of depression, is it merely his conclusion about depression that you're relying on? Mr. Khan says, objection. Hold on. Sorry. He says, objection. I will object to any references to any conclusions by any witness who's not on the witness stand. Sustained. That's stupid. Usually experts can testify, hey, I read this other expert's report and this is what they said. This is the dumbest, like, this is so dumb that he can't or she can't bring it in this way. Ms. Emerson says, I don't even know if he had such a conclusion. Let me ask you, she says to the witness, are you basing it on conclusionary language or language describing symptoms that were observed or that Dr. Vickery wrote in his notes, symptoms that Erik Menendez was displaying? Mr. Khan says, objection, calls for hearsay. The court says, all right, the bottom line is you reviewed Dr. Vickery's notes and you're relying upon that for your diagnosis. The witness says, correct. The court says, oh, let's take our recess and we'll resume at 1:30. Don't discuss the matter and don't form any final opinions about it. We'll resume at 1:30. And they take their lunch. And that is where I leave you. So that's so stupid that they can't. Experts on the stand are supposed to be able to just, talk about other experts' reports that they've referred to, relied on, anything about, they're supposed to be able to talk about it because they're also an expert about the topic. So why can't the defense bring in the fact that this this witness also reviewed another witness's notes? This is so stupid. It is so biased. Everything in this trial has been just anti the Menendez brothers with the way that things have been playing out, with the way that the court's orders have been um, resulting in. And usually it's resulting in the defense losing whatever it is, motion or objection or whatever. And the defense, their hands are tied for a lot of it. So, all right, that's it. I have to get out of here. So thank you guys so much for watching, and I will see you in the next one. Please hit the like, subscribe, all those good things, and I'll see you in next, what is this video? This is Tuesday's video. I will see you guys on Thursday. Take care. That's the end of this Trial Transcripts Exposed. Thanks for following along with me. Want more? Subscribe and let me know what you think in the comments below. See you next time.